This video is brought to you by Legaleagle's CopyrightCourse.com, giving all creators the tools they need to fight bogus copyright claims. YouTube stands up for creators everywhere and fights back against an alleged copyright troll who not only apparently tried to extort fellow YouTubers, but tried to have one killed. Yep, it may be true. This case is wild. Hey Legaleagles, it's time to think like all of the lawyers that YouTube just hired to go after a copyright troll who may have been trying to extort a bunch of individual creators. YouTube has filed a federal lawsuit against a YouTube creator who they claim was trying to extort fellow creators and actually may have swatted one of them. Now, before I begin, I want to emphasize that these are only allegations. All of these facts come from the complaint that YouTube filed in federal court. A complaint is the document that you use to start a lawsuit, and it contains your side of the story. YouTube is the plaintiff here. That means they started the lawsuit, and because we're still in the very early stages of this particular lawsuit, all of the facts are going to come from YouTube, so take everything with a grain of salt. Now first, let me give you some background to help understand this lawsuit that YouTube has filed. Congress passed the DMCA in 1998 to deal with copyright infringing material online. It allows websites to not be responsible for copyright infringing material that its users upload under certain circumstances. The DMCA is one of two laws that give websites a safe harbor, the other being the Communications Decency Act Section 230, which is something I will definitely cover in the future because it is in the news every single day these days. The bottom line is that under the DMCA, a website isn't liable for copyright infringing material so long as they take down the offending material when they receive a notice from the person that owns the copyright. This is called a DMCA takedown notice. You'll find it in 17 U.S.C. 512, which is a totally easy law to understand. You can look it up by searching Google for 17 U.S.C. 512. Now, YouTube asserts in its complaint that one Christopher Brady issued a false DMCA takedown notice to extort certain YouTubers, people that made Minecraft videos. Basically, the complaint alleges that he claimed he owned the copyright to Minecraft and therefore demanded that YouTubers pay him money or he would issue a DMCA takedown, a third one. Now, YouTube has a system where if you receive 3 DMCA takedown notices, your channel is deleted. When a DMCA takedown notice is levied against your channel, YouTube gives you a strike, and 3 strikes and you're out of the YouTube game. Now, allegedly, Brady would issue 2 DMCA takedown notices and then try to extort hundreds of dollars from those creators by threatening a 3rd takedown notice, which would result in potentially the deletion of these people's channel. Now, if true, this is illegal and violates the DMCA Section 512. This happens. I've talked to creators who have dealt with false DMCA takedowns. I myself have been the victim of a false DMCA claim, so this is definitely something that exists in the world, but it's also relatively unusual. The big boys, the music labels and the movie studios, rarely mess around with DMCA claims. Now, sure, they abuse the content ID system that YouTube has created, but a DMCA takedown notice is a little bit different. It's created by copyright law, and YouTube doesn't have a whole lot of control over it. Basically, from the people that I've talked to behind the scenes, none of the big players will file a DMCA takedown without talking to a lawyer first, or often they'll have the lawyer issue the DMCA takedown. Why is that? Because it's a big deal. As paragraph 8 of YouTube's complaint states, to submit a takedown notice using the form, parties must affirmatively check a box next to a statement that reads, I acknowledge that under Section 512F of the DMCA takedown, any person who knowingly material misrepresents that material or activity is infringing may be subject to liability for damages. If you issue a false takedown, not only are you liable for damages, in other words, the loss of revenue that comes from the videos, but you're also liable for attorney's fees. And when you're talking about YouTube, that's a lot of fees. Now, I know YouTube gets a lot of flack for taking down videos pursuant to the DMCA takedown requests, but YouTube actually doesn't really have much choice in the matter. That's apart from the whole Content ID system, which YouTube controls. Paragraph 9 of YouTube's complaint says that YouTube receives thousands of DMCA takedown requests each week through its online web form. It also receives notices by email, postal mail, and facsimile. I'd guess that, if anything, this is probably an understatement. I'd guess that YouTube probably deals with on the order of millions of DMCA takedowns takedowns per year. And YouTube doesn't really have much choice in how to deal with these particular claims. It's all enshrined in copyright law, both the time frames and the consequences. So if YouTube gets a DMCA takedown, they don't really have much choice but to take the video off of YouTube. Otherwise, YouTube would potentially lose their copyright safe harbor and become liable for thousands, if not hundreds of thousands of copyright infringement actions per year. So let's talk about the actual facts of this case. In paragraph 21 of the complaint, YouTube alleges that in January 2019, defendant Brady, using several falsified identities, sent YouTube multiple notices of alleged copyright infringement pursuant to the DMCA, claimed that 2 videos uploaded by Kenzo and 2 videos uploaded by Obby Raids supposedly infringed copyrights that he owned. In the next paragraph, YouTube asserts he represented that he was the original creator of those videos and that he held the copyright to them. The complaint goes on to assert that Brady tried to extort a third YouTuber, and in fighting one of those allegedly false DMCA takedown notices, that YouTuber provided his true home address as required by law. That makes sense. That is one of the statutory requirements to being able to fight a DMCA takedown notice. The problem, as alleged in this complaint, is that part of the DMCA allows you to issue a subpoena to get that information when it's uploaded. The purpose of which is that if you are issuing a DMCA takedown, you need to be able to take these people to court if they file a counter notice and put the video back up. The complaint goes on to assert that on July 10th, the third YouTuber announced via Twitter that he'd been the victim of a swatting scheme that day. And they go on to define swatting as the act of making a bogus call to emergency services in an attempt to bring about the dispatch of a large number of armed police officers to a particular address. If that's true, that this guy did use the information he gained by abusing the DMCA takedown process to issue a false SWAT call against a fellow YouTuber in the hope that the SWAT team would be called to this guy's actual house, that's a felony and this guy should be in jail. This is a despicable act if true. People have died because of swattings, because if you're playing a video game that involves gunfire and the SWAT team hears the gunfire from the outside, they might come in with guns drawn and people have died in the course of being falsely swatted. The bottom line is that YouTube alleges that this particular individual, Brady, falsified DMCA takedowns, committed perjury, and used that information that he gained to extort fellow YouTubers and may have even tried to kill one of those YouTubers. Frankly, I was astounded when I saw this lawsuit being filed by YouTube. 17 U.S.C. 512F does in fact give service providers like YouTube a private right of action to sue over false DMCA takedown notices. I've just never seen a service provider actually file a suit like this. If true, this seems like a very, very good thing on behalf of most YouTubers and a blow against potential people who are trying to abuse the copyright process for their own ends when they don't own the copyright to allegedly infringing material. This could be the first of many lawsuits on behalf of YouTube protecting its YouTubers, and if indeed the allegations in the complaint are true, I think YouTube is doing all of us a favor by getting rid of some of these YouTube copyright trolls. I think YouTube is trying to send a message against this troll and potentially others. They have the resources to do it, and I will repeat that we don't know all of the facts. This is all one-sided, so please do not dox the defendant Brady or attack him in any way online. Let this legal process play out. YouTube, in its prayer for relief, is asking for compensatory damages, attorney's fees, and an injunction. In other words, a court order that forces the defendant to stop. This is probably bad enough. I checked, and this case is being litigated by a local firm in Omaha where the defendant lives, and also by a very well-known attorney with one of the top-tier law firms, Wilson Sonsini, which is the law firm that has handled Google and YouTube's most important and famous cases. And I was curious how much Wilson Sonsini charges, and according to court documents, if you can get a 10% discount for a lead partner at Wilson Sonsini, you will only pay $900 an hour. In other words, if this defendant loses, he'll probably pay on the order of $1,000 per hour for hundreds of hours of attorney time. Also note parenthetically that Phil DeFranco covered this lawsuit earlier today, and although he did generally a great job covering it, he put some special attention to the end of the complaint, specifically the prayer, which asks for such other, further, and different relief as the court deems proper under the circumstances.
Kind of a question mark, saying they pray for such other, further, and different relief as the court deems proper under the circumstances. Right, so something even potentially bigger here.
He kind of freaked out about this. That's a totally normal thing to put in a complaint. It's just a catch-all, a lawyer's CYA to allow them to ask for something else not specifically mentioned in the complaint. So Phil, my dude, reach out to me next time. I'll let you know what is notable or not in a complaint like this. As an attorney, I have dealt with copyright trolls for a very, very long time, and I am tired of creators getting pushed around by bogus copyright claims, so I decided to do something about it. I made copyrightcourse.com to give all creators the tools that they need to fight meritless claims and stand up for their rights online. It's not only an entire law school course on copyright distilled into a few hours, but it's also a system that I developed to fight claims on YouTube and other platforms. I should know because I get a lot of claims against my videos, even though they are clearly fair use and, spoiler alert, made by an actual copyright attorney and trial lawyer. Copyrightcourse.com is all the tips and strategies that I use to beat claims and make sure my videos are safe. I think it's time that we fought back against the copyright trolls and made fair use actually fair. You can check it out at copyrightcourse.com right now, and you can get early access to the beta course, which will be half the price of the final course. You'll get every module as soon as it comes out, and your comments will help shape the final product. I am really looking forward to being able to help creators and fight back against the copyright trolls, because there are a lot of them out there. So, do you agree? Leave your objections in the comments, and check out this playlist that has all of my other real law reviews over here, where we deal with all of the pressing legal issues of the day. So click on this playlist, and as always, I will see you in court.